I know. I mean, making mistakes is something humans cannot avoid, right? But then we also have a lot of mistakes when applying for H-1B visas, the documentations, and today we're going to get some tips, and a lot of things to discuss about that. So, friends out there, stick with me. Hello, everyone. Welcome back to another enlightening episode of Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and today we have a special guest joining us to delve us, into this crucial topic regarding H-1B visas that we're going to discuss today. And we had him with us last week. We spoke about many things, including the H-1B cap filing for the year 2025, the lottery process, the H-1B, multiple jobs, and many compliance issues. We discussed so many things. And friends, he is none other than Attorney Chand Parvataneni from Dallas, Texas, United States, and from the law firm of Sim. And without further ado, please help me welcome him back to this show. Big hello to you, Attorney Chand. Thank you for joining us once again.
Thank you, Dipasa, and welcome everyone that has joined us today. And thank you so much. We'll again have a very informative session. It's going to impact a lot of filings. The H-1B cap season is down the line. It's going to start in about a month. It's going to start in March. And
Right.
I'll try to use my experiences, what we do at our law firm, what we've done in the last decade at our law firm, and hopefully give you some pointers and tips that will make this H-1B filing process a very, very smooth and a very easy process.
Absolutely. And friends out there, wherever you have joined us from, whether it's YouTube, LinkedIn, Facebook, please, you know, can we have the disclaimer once again? Please read the disclaimer once more before we start off. And yes, by watching this video, friends out there, our videos, whether you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is actually not legal advice. So, use of these informations is all at your risk. And yes, Attorney Chand, we spoke about many things last time, like we were saying, and many comments are still flowing, actually, So, if you could actually brush up a little bit, explain once again, because people are still assuming that it is based on the number of companies filing. So if you could just clear that off, it'll be very nice.
Sure. So the H-1B lottery process, the registration process, it's starting next month, March 6th. And I think USCIS has announced the new rule changes. They finalized those rule changes. We talked about it in the last session. And a lot of people, there's a lot of confusion, and people have a lot of questions on what exactly is changing and things associated with the change. To summarize, the main thing is USCIS is trying to make it fair to everybody. People were gaming the system. We've seen beneficiaries gaming the system by going to multiple employers, employers gaming the system by filing multiple registrations, by colluding and filing multiple registrations. So
Mhm.
USCIS came back and gave a very simple solution. They said we are going to have a beneficiary centric approach. Beneficiary centric approach, all that means is everybody will be entered into the lottery based on their passport,
Mhm.
not based on how many number of companies have filed their registration. Last year, the more number of companies filed somebody's registration, their chances increased by so many times. This year, no matter how many companies do the registration, everybody is going to have the same exact chance based on their passport. So that is what they mean by beneficiary centric. It is not
Mhm.
employer centric. Last year, it was employer centric. So every employer's registration was considered a separate entry into the lottery, which is why the folks that have had more offers, they had more chance. This year, everybody's passport gets put into the lottery, so everybody has the same chance. Again, there are
Equal
two ways.
chance.
One, yeah. So they have two ways again. One, if you have a master's degree, a qualified master's degree, you come under the 20,000 quota. And if you don't have a master's degree, you come into the 65,000 quota. But that being said, everybody has the same exact chance this year. The confusion that I'm seeing come out this year is, yes, we understand that everybody gets only the same amount of chance because the unique passport number being used. But what if I do have multiple job offers? What happens in that case? Again, USCIS has clarified that part. If somebody has multiple job offers, which is the main question that I'm seeing a lot of people ask us, if someone has multiple job offers, that is good. The rules were there from a long time back. If multiple companies file, it is not going to increase anybody's chances. So, because they're using the passport, if the employee's passport is selected, then what is going to happen is, if multiple companies register him, the multiple companies will have a choice. So they can, uh, so all these companies that have registered for the beneficiary, they will get a notification saying that the employee is selected. And what that means is, the employer, from their perspective, they are ready to go ahead and file the petition. So what that means is, yes, multiple companies can still offer employment and they can register. The caveat is, the companies should not be related, they should not collude, and every company that is registering should have a bona fide job offer. If the companies are not related, they're not colluding, the job offer is bona fide, yes, multiple companies can still register. That being said, nobody's going to have any additional preference or any additional advantage in the lottery, except that the employee will have a choice. So the employee can still decide. They will have some additional time to decide which offer they're going to pick up. But from a probability perspective, it is not going to make it any easier if they have multiple registrations. So that being said, collusion is still the law. Everybody has to ensure there is no kind of collusion and they're only accepting jobs that are bona fide. If somebody is filing for a registration and there is no bona fide job offer, that is a fraudulent registration. And what that means is, tomorrow, USCIS, even if they approve the case, they can go back and revoke the case. So they have authority. So everybody has to be cautious. Uh, yes, they can accept multiple offers, but accept them only if you know the company is genuine and only if you know the company really has a genuine job offer. Otherwise, irrespective of the fact whether you have an additional chance in the lottery or not, even though it is beneficiary centric approach, the attestations have not changed. The attestations on the registration, they are still the same. The companies still have to attest that there is no collusion. They still have to attest that the job offer is bona fide. So that part of the law is not changing.
Right. And friends out there, that is none other than esteemed immigration attorney Chand, and of course, these are topics we caught up last episode, and we have questions actually, on Facebook and even on YouTube. One is from Prakash IL New. How can I apply for the same? So I would just request you to go check out the episode we had. It's published on YouTube in our channel. So it'll be great if you could just go give it a watch. And of course, stay tuned because today we are going to cover this topic, mistakes when applying for H-1B visas, the documentation, and tips, and especially specialty occupation RFEs. So, of course, this is esteemed attorney Chand. And, whether um, I think we should just go ahead and shoot my questions first. And if you have any questions for Attorney Chan, please feel free, to comment, and we'll love to take up your questions after my questions are done towards the end of this. So please stick with us. So, what are some of the most common mistakes you've seen, applicants make when applying for H-1B visas?
Sure. So this is very important. There are some common mistakes that I see all the time, and people can just avoid them. So when we say applicants applying for the H-1B visa, it's a two-step process. The company has to initially file the petition. So that is step number one. So it is not the applicant, it's the company, the petitioner. So the petitioner does the H-1B filing initially. The case gets approved, and down the line, the employee, who's the applicant, the visa applicant, they go for stamping and they get the H-1B visa issued. And in between this entire process, the first thing starts off with the company and the employer and the employee, the applicant, the visa applicant, and the employer. So it starts off with their initial discussion, and the company making a job offer and the employee accepting the job offer. At that point, the petition gets filed. So the very first
Mhm.
step, I see a lot of people making a grave mistake. People reach out to shady companies. People reach out to companies that are not genuine. People want to pay the H-1B filing fees. So there's a lot of things
Mhm.
that happens. What everybody should be very, very cautious is you have to work within the framework of the legal regulations. One cannot pay a company to file their H-1B. That is the first mistake that I start off seeing people. The reason is lately at the visa consulates, there is a lot of scrutiny. During site visits, there is a lot of scrutiny. USCIS wants to know if the employees are paying the employer. The big companies typically don't do it. The small companies, some companies, not all, but some companies are in this habit. So, and
Mhm.
USCIS is very particular. And what that means is if you go through a company that is not a genuine company, you don't have enough referrals for that company, and you go and get an H-1B file, the case gets approved. USCIS finds some law has been broken. They go back and revoke the visa. So this is the first thing that I think is a very common mistake. People accept an offer without getting enough referrals or doing enough research about the company. So the first thing where everybody should start off is research the company that is going to file your H-1B. It's not easy. I mean, like, it's not difficult. A lot of information is public. A lot of information on how long the company has been in existence, how many number of employees the company probably has, what kind of filings they have done in the past. A lot of it is public information. So the first thing, make sure the company is genuine, make sure the company is legitimate, make sure you at least know
Mhm.
someone that has worked for the company if possible. So that's the first most important thing. And the next most important thing is the common mistake uh, is uh, the occupation. The occupation is very, very important. And again, this is from the employer perspective and the employee perspective. Not all occupations qualify for H-1B, which is why the biggest part of our topic for discussion today is specialty occupation. We'll talk about it down the line. It has to be a specialty occupation for USCIS to approve the case. Very important. So what that means is when the employer and the employee, they're negotiating their scale, their pay, and their duties, one has to be aware that the occupation has to meet the specialty occupation standards. The salary has to meet a minimum requirement. So this is another thing where employee, employer, they have to be very careful, ensure it meets the requirement, the H-1B requirement of that occupation. And another common mistake people make is they rush into a filing. So what that means is they wait until the last minute, they rush. And at the last minute, they don't have documents to prove their status. For example, their pay stubs are missing. Their transcripts are not complete. Maybe they have their mark sheets. They don't have their degree certificate. Their passport is about to expire or has just expired. They don't look at their passport. So the common
Mhm.
things are everybody should be looking at their documents that are required and take it very seriously, and don't procrastinate. Don't wait until the last minute, and get all the documents ready. You want to make sure you give the documents to the USCIS officer. You don't want to give the
Mhm.
USCIS officer a chance to find any ambiguity or find a reason not to understand the documents. So what that means is the process is not that difficult, but somebody has to be careful, put due diligence, and make sure they provide all the right documents on time. So procrastination is another common mistake we see. They wait until the last minute. Their status is about to expire. They are supposed to apply for an extension, or they're
Right.
close to the deadline and their H-1B has not been filed. Tomorrow there is a FedEx problem and they missed the deadline. So these are the kind of common mistakes that we see that could be prevented by being a little bit
Mhm.
diligent.
Absolutely. So, friends out there, earnest request, no procrastination, and do your research properly wherever you go. All the very best. But yes, you don't want to make any mistakes and you don't want to take any chances. So, do your bit, okay? Do your homework properly, and everything is going to be all right. All right. So, maybe could you share some insights, into the importance of thorough documentation in the H-1B visa application process?
Sure. So the H-1B visa, I mean, when you apply for a H-1B filing, you go through the company and the company files a petition. So typically it's a one-shot chance. What that means is you prepare all the documentation, you give it to USCIS. and you cannot keep adding documents. You find out that you're missing a document. You can't go and mail that document back to USCIS the next week. You can't do that. So it's a one chance thing. Again, if something really is majorly missing, they give you a request for evidence and give one more chance, one more final chance. That being said, we don't want anybody to be in a situation where USCIS is giving a request for evidence. What that means is, with the documentation, we should be as thorough as possible. We should meet all the mandatory documentation requests, ensure it is there with USCIS. And our goal is ensure that the officer clearly understands what's going on. Ensure that the officer is not confused, because if the officer is confused, there is a huge problem. I'll give a simple example. Somebody has, for example, a civil engineering bachelor's degree, but they came to US and they have a master's in computer science. So if the officer knows the employee has a master's in computer science, even though they have a bachelor's in say civil engineering, that's okay. That's not a problem, because they have a degree that's computer science. But in the documentation, if somebody is not clear and somebody is not able to show that this person has a master's degree in computer science, but they highlight his bachelor's degree, the officer might miss the important part of the documentation, assume the employee is not qualified. And now it's not just a simple RFE for beneficiary qualifications. They might even issue a specialty occupation R.F.E., which tends to be a little bit more complex. So the bottom line is, sometimes you can resolve something very easily by ensuring the officer is not confused. Just put it very clear in front of the officer. Don't confuse the officer. You don't really have to give hundreds and hundreds of pages of documentation. Be very concise. Be up to the point. Don't confuse the officer. We typically don't like documents that are running into thousands of pages or hundreds of pages. The goal is,
Right.
H-1B is not complex. It's simple, but keep it simple. Make sure the officer is easily able to flow through the petition. And don't confuse the officer where things are so ambiguous that the officer is not able to understand and he's issuing a huge big RFE just because things were not properly explained. So the bottom line is, know what things are mandatory, what things are essential, and don't flood the officer with tons of documents. This is not like a discovery request that happens in a lawsuit where you're flooding the opposite party with like tons and tons of documents. H-1B is a different way of doing things. We are working with the administrative agency. In this case, it is USCIS. And what that means is, unlike the lawsuits or litigation where you flood the opposite party with a lot of documents, you don't want to overwhelm the officer. You want to just keep it simple, provide only those documents which are required, which are clear, and doing so, you're not going to confuse the officer. Things are going to be super clear, and the officer also can quickly go through the file and process the file. So overall, be very, very concise, up to the point, ensure the documents clearly explain what we want, and the flow is very smooth.
Absolutely. So for smooth flow friends out there, keep it to the point, I would say, just whatever is required. See that, you have all of those documents and maybe in order as well, so that, the officer is also with you and on the same page. So let's move on, Chand. Let's move on to the next question that I have for you. And that is, if you could share some key documents that applicants often overlook, to or underestimate even the importance of when applying for an H-1B visa.
So the most common document that we always come back with multiple cases is the degree certificates. A lot of times,
Okay.
people have the mark sheets, because mark sheets come every semester or every year. So people have the mark sheets. They don't have the actual diploma. And this happens more for people with a master's degree. They have all their transcripts every semester. They don't have the final diploma copy. USCIS, on the
Okay.
other hand, they don't just look at the transcripts. They also look at the degree certificate and H-1B filings. A lot of them, especially the CAP filings, they have a deadline. So we go to the last minute and people say, hey, we have the mark sheets. They prove that we've attended the classes. They prove that we have graduated. Unfortunately, it doesn't. All it proves is somebody has taken some classes and they've passed those classes. The degree is what tells USCIS that they're actually been conferred with a degree. So what that means is, don't wait until the last minute, because sometimes the universities, the schools, they take time to issue the diploma, the degree certificate. So be very, very proactive. Start now. Everybody who's in the process of applying for the H1, you need to have your mark sheets. You also need to have your degree certificates. Very important. So it's together with your mark sheets and degree that will qualify you, not one without the other. Very important. Another important thing is passports. We come into this problem where people legally change their name, maybe because they got married and their passports are reflecting the old name, or their passports are about to expire and they don't realize that. And then it is time to apply for the H1 and they realize the passport is expired, because typically you get 90 days once the lottery is done for the cap filings. And initially the passport might be valid, but during the 90 days when you're about to file the actual petition, you just realize your passport is expired. You're running back and forth. So don't wait until the last minute. Check the passport. We have had so many cases where there was a deadline, either because somebody's status was expiring and we had to do a rush H-1B filing, and then we realized somebody has not extended their passport. Very important. So everybody should be looking at their passport. Ensure your passport is up to date. Very, very important. Another thing, especially for the cap filings, every time you are in US and you move your addresses or you change your job because you're on OPT or STEM OPT, there are some reporting requirements. You have to go back to the school. You have to notify your DSO that you're changing your job. You are supposed to go back to USCIS if you're changing your address. So there are some reporting requirements. People come to us at the last minute and then tell us, we have not notified USCIS about our address change. We have not notified our DSO about the reporting requirement for our employment changes. So what that means is, everybody, don't overlook your address changes. You have a burden to notify USCIS by filing AR11. Every time you move, you have to file the AR11. Every time you change your jobs, especially the folks with OPT or STEM OPT, you have a requirement, a reporting requirement. You have to go back to the school DSO. So don't overlook these minor things, because sometimes people are under the impression that, hey, I'm doing what I'm supposed to do, which is attend classes, do a job, but forget these reporting requirements. So reporting requirements are very essential. Ensure your address changes, your job changes are appropriately reported to the right parties. Very important. And then your documents, your passports and your mark sheets. Make sure at all times you have access to those documents, and you also have a soft copy. You don't want to be rushing for those documents at the last minute. There are filing deadlines and there is going to be a rush. Your status expires, your I-94 expires, the employer has to file an extension before that date. You're doing the cap filings, June 30th is the deadline. You can't extend the deadline. So deadlines are super crucial. And what that means is, everybody should know what documents are essential, and don't overlook any documents or any of these reporting requirements.
Absolutely, friends. So you heard Chand, Attorney Chand here, and I would just say check on your documents and whatever, like he has said, like whether it's maybe some spelling mistake or maybe address change, uh, all of those things, please keep them all up to date. And of course, keep on checking your passports that they are also, so that if you have to go and refresh, or I mean, I hope you get all of that done as soon as possible. And yes, if you have direct questions to Attorney Chan Parvathaneni, you can contact him, mail him at law@spblawfirm.com, or call him in the number 817-523-8247. And definitely visit his website, spblawfirm.com. And yes, he's in charge of green cards and H-1B. And we have a lot of folks out there who are, asking. There is Sudarshan DBI, if I'm pronouncing it right, from Facebook saying, could you provide the links where we can find the previous webinar? So I would just say, please check out our channel on YouTube. We are there as Immigration and Jobs Talk Show. You can check all of our webinars that we have had in the past, and definitely with the Tony Chand we had last week, and we covered up a lot of topics and touched on many topics under the H-1B visa, the mistakes, and everything. Just go watch it, I'll say. So, and also, you could contact me at nipa@hireitpeople.com, or call me on the number 408-335-6444, or visit our website at www.hireitpeople.com. And Chand, I have this next question before we move on to the break. I'll have a couple more questions. And this one is for specialty occupation RFEs. They can be challenging to navigate. So, what are some proactive steps applicants can take to minimize the risk of receiving such a request?
Sure. So the good thing is lately we don't really have very bad RFEs like we used to have in the past. Employer-employee relationship, availability of specialty occupation work, and a lot more complex RFEs that we used to get in the past, or wage level one. So those kind of RFEs that used to come a lot in the past. So the good thing is most of the RFEs are pretty simple, but out of the current RFEs that we typically get for H-1B filings, I would basically classify the specialty occupation RFE as probably the most complex RFE right now. The reason is to qualify for H-1B, you have to prove that your job is very specialized, very complex, and it does require education in a specialized field. That is what we have to prove. Whenever you get attacked with a specialty occupation RFE, the officer is basically saying, we don't think this job is complex. We don't think this job is specialized. We don't think this job requires a 4-year bachelor's degree to do the duties. That is what the officer means. And they are putting a huge burden back on us. And that is why this RFA is complex. How do you minimize it? So in terms of minimizing, sometimes even if you do everything right, you can't avoid this RFE. But again, I think if you want to minimize it, what are the strategies? Definitely, the main thing is always look at your occupation. The occupation cannot be any occupation. If I say, can I hire somebody to work as an office assistant? Probably not on H-1B, because office assistant is not a specialized career. That being said, if somebody says, can I hire a software developer? Software developer in general, it is specialized occupation. How do we know it? There are two places normally one has to check: Occupational Outlook Handbook and then Own It. So typically, the company and the attorneys, they have to make sure that the occupation is actually an occupation that meets the standards of specialty occupation. That is one important thing. What that means is, from an overall perspective, there is something called an Own It code. Everybody that has an H-1B filed will know that they have an LCA. The LCA will have something called an Own It code. That Own It code is very important. So to minimize the specialty occupation RFE, be very cautious about the Own It code you're using. That Own It code should rightly reflect your job duties. Very important. And it has to be the right Own It code. So choosing the right Own It code will minimize somebody's chances of specialty occupation by more than 90%. If you choose the right Own It code and a qualified Own It code, that itself will reduce your specialty occupation RFEs by a lot. The next major important thing is wage level. When you do an LCA, so everybody who has been with the H-1B process will know that there is something called an LCA, and that LCA will specify what is your wage, what is your salary. And there are 4 wage levels. So the wage level has to be appropriate for the job duties. So if the job duties and the wage level, they don't match, if the job duties show that it is a very, very senior level job, you require a lot of experience, but then the wage level does not reflect the right amount of experience required, there is a clash. USCIS is going to go back and say, hey, we don't think this job is specialized, because you're saying it's an entry-level job and the duties are too simple, so maybe something is wrong. So always make sure the wage level and the Own It code are appropriate. That will decrease the specialty occupation RFEs by a lot. And the burden for that is with the employer and the way they define their job duties. And the next most important way to minimize specialty occupation RFEs is give a very, very detailed job description. And we keep telling this to the employers a lot. We expect the employers to explain to us what is the technical role for the employee. So the employer, they have to give a job description. That is very important, and it is pretty much mandatory for every H-1B filing. You have to give the job description to USCIS, and that is the technical job description. And sometimes, no matter how many times we tell the employers, sometimes the employers give only like 2 or 3 lines of job duties. That is going to increase your risk of RFAs by a lot. If you give a very detailed job description, and we always say, at least explain it in at least 1 whole page, not just like 3 or 4 lines. If somebody can give a very detailed job description of at least a page, So all that means is increase the detail in your job duties. Make it as detailed as possible, at least a page. Then the officer can really see the complexity in the job duties. If it is too simple, very, very simple job duties, USIS is going to attack and say, this is too simple. So give a detailed job description right in the beginning of your submission. Don't wait for the RFE. So doing these two things, people are going to minimize their job duties, their risk of specialty occupation by a lot.
Absolutely. I think it's very important to keep it transparent, so keep it updated, keep it transparent, and uh, see that whatever you're dealing with, everything is up to date. And I think everything is going to flow after that, right, Tony Chan?
Mhm. Yes.
All right. So I have another question before we move on to a break, and in your experience, if you could just share what are some of the most common reasons, applicants receive specialty occupation RFEs.
So most of the time it is because the job description is very poor. So sometimes the job description is so simple, the officer is not convinced that it is really complex. First one. Second time, sometimes if the wages are low and the wage level is low, officers tend to come back and say it's such a junior level job. Do you even require a bachelor's degree for such a junior level job? So the salary is very low and the wage level is very low. We typically tend to see this RFS quite a lot. That's the main thing. And the third thing is the occupation. Sometimes some occupations are just prone for specialty occupation RFEs. For example, if I say just a basic web designer, HTML designer, the ONET code probably is not very specialized. The job zone is like a low level zone. So, but again, if you say a software developer, the occupation of software developer, it is a specialized occupation. So that the risk of a specialty occupation RFE for a software developer is typically very low. So there are like a lot of occupations. Some occupations, because the Own It Online or the Occupation Outlook Handbook, they don't say that a bachelor's degree is an entry level requirement. So there are some occupations which are highly prone to specialty occupation RFEs. So when we go and see job duties where they can fit into multiple occupations, we typically want to go and sit and work with the company on using the right Own It code. So most of the time, weak job duties, weak occupation, and weak documentation in general are the causes for specialty occupation, RFEs.
All right. And friends out there, I'm sure you have a lot of questions and there's a lot going on in your head and you want to clarify a lot of your doubts as well. So, whatever it is you want to ask Attorney Chan, please drop in your comments wherever you're watching us in Facebook, LinkedIn, or YouTube. And whether you're an employer sponsoring H-1B candidates or an individual seeking this visa, even, we're trying to understand the intricacies of these application, the process, and everything that is essential. And today we have this opportunity with none other than Attorney Chan. So stick with us. We'll just go for a short break because we have a lot more to discuss, but stay tuned.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back after the break, friends out there. I'm Napasa Pradhan on Immigration and Jobs Talk Show, and today we have with us this esteemed immigration attorney, Chand Parvathaneni, and he has been sharing valuable insights on common mistakes while applying for H-1B visas, the documentation tips, and we are right now navigating through specialty occupation RFEs, and of course we have so much to ask, but yes, I think let's check this one out by Prakash Ariel New. How can I apply for the same?
So Prakash, so when you want to apply for a H-1B, you have to find an employer. And the way it works is you always need a sponsor, which is the employer. So you reach out to the employers who have openings. And if that employer gives you a job offer, the company will have to apply for the H-1B. And the way they do it is initially they have to go through the H-1B registration, which is the lottery process. You get selected. And once you get selected, they have to file a petition. They have to file something called an I-129 petition with USCIS. And once they get an approval, you have to go for a visa stamping. And that is how typically you'll be able to apply for the H-1B.
All right. And also, I mean, a lot of folks out there are still commenting. Yes, Dare Oluwadamilere. I'm sorry if I'm pronouncing it wrong. I'm also interested to apply. All right. So you should. You should. And if you have any questions, definitely contact Attorney Chand himself. And we also have LinkedIn users, and we have Andre on YouTube. How can I demonstrate to the USCIS that my job meets the criteria for a specialty occupation? And what evidence should I provide to avoid a request for evidence, RFE?
Sure. So when you do the filing, so this is what you do. You give your detailed job duties, very important. So once you give your detailed job duties, you also let USCIS know what are the degrees that are acceptable based on the industry standards and the company standards for that particular job. For example, if somebody is doing, say, for example, a job of a database administrator, for example, you list out all the company will list out all the detailed job duties, what kind of database servers they're tackling, what kind of underlying architecture they're working on, and all those things. So they will define the job duties. And at that point, the company has to go back and let USCIS know, because this uh, these detailed job duties require knowledge in so and so fields. These are the kind of fields that we require to qualify the beneficiary. And what that means is you have to show some nexus between the job duties, and you have to show the correlation between the degrees that you're asking. For example, a company can say something like, for doing these job duties, I require computer science degree, software engineering degree, and information technology degree, or closely related degrees. And you show a nexus because, yes, these are all IT and computer science job duties. And the degrees you are asking, they are related. That is how you show nexus. USS will be satisfied. But then you go back, for example, if a company has said, for doing this job duties as a database administrator, I require, for example, computer science, um, IT, and any engineering degree, for example, because some companies do that. They go back to the USCIS and say, we require and we hire from any engineering degrees. Then USCIS typically will come back and say, if anybody with any engineering degree can do this job is in an IT field. We don't see the nexus, we don't see the correlation between, for example, your duties and, say, mechanical engineering or civil engineering duties. Where is that nexus? And that is the first trigger to see a specialty occupation RFE. So what that means is provide them the detailed job duties, provide them the degrees that you require, and provide them the evidence. The evidence as in, hey, this is what the Occupation Outlook Handbook says. So this is the occupation, and for this occupation, according to the Occupation Outlook Handbook, these are the degrees required, which is why we require these degrees. Show the correlation, show that as an industry standard, only closely related set of degrees do qualify somebody for this position. So that is how you would prove it. So prove the narrow set of degrees, prove the correlation, and then show the evidence through Occupation Outlook Handbook or some industry standards.
All right. Andre, I hope you got your answer. And there's another LinkedIn user, it's anonymous. He says, may I use opt payrolls for H-1B transfer before October 1st?
Sure. I think what I understand from this question is if somebody gets an approval, say in the cap lottery, because you filed by June, and say you get an approval, and if somebody gets an opportunity with another company, can they file a transfer? The reason is So for the CAP filings, the start date is October 1st or later after October 1st. So even before October 1st, we see this happen every year. Some people want to transfer their companies if they have better offers before October 1st. Theoretically, it can be done, and we have done it. The caveat is you can do the transfer. You can, if you have another employer, you have a better offer, and you want to use the initial approval to transfer to another company, it can be done. The caveat is your H-1B petition should not be withdrawn. So the company that got the first approval, if they submit a withdrawal request or a revocation request, the case gets revoked before October 1st. You cannot file a transfer. But say the company is not withdrawing the case or not revoking the case, then absolutely yes, you can file for a transfer even before October 1st.
All right. So, well, I would just say keep your comments and questions coming. We'll take it up a little later. Now we'll move ahead with some more questions that I have for Attorney Chand. And I hope that as we discuss, you also have your doubts cleared and questions answered. So, how can applicants effectively respond to specialty occupation RFEs to improve their chance of approval? Attorney Chand, if you could help us.
Sure. Say somebody, I mean, in spite of all the efforts, they did get a specialty occupation RFE.
Mhm.
So at that point of time, there are certain things that one can do to get an approval. And those things are, again, the first thing that we normally do is we say, hey, company, go back and you did submit your initial job duties. Sometimes they're probably good. Even though they're good, come back and add more detail and add the percentages for every line, every duty. Maybe say how much percentage of time one is going to spend. Give more granularity. And then we say, hey, let's get an expert opinion. And what is an expert opinion? So in this field, typically a college professor is an expert because they are in this industry, they are educated people. So we get an opinion from a college professor, a university professor. We go to them and say, these are the job duties. What is your opinion on these job duties? And the professor, they can give their opinion and describe their opinion to USCIS and say, hey, because of these reasons, we think this job requires a degree in so and so fields. Expert opinion. Expert opinions are expensive, but it is a great way of tackling specialty occupation RFEs. So almost always we go back to an expert, a professor. For example, it's a computer science job. We go to a professor who's teaching in computer science. If it's, for example, a mechanical engineering position, we go to a professor who's a professor in mechanical engineering. So some relevant professor, we go get their opinion. Expert opinions are very, very useful most of the time. And sometimes what we do is we also show the hiring standards of the employer. So we go back and say, look, this employer for this particular position, they've hired in the past, and every time they've hired people only with a valid degree. So we show that evidence. That's another very great way of proving specialty occupation. And sometimes a client can also help prove that. Suppose somebody is working on a client assignment, and if a client gives a letter saying, as per our standards, this job does require a bachelor's degree in a specialized field in so and so fields. A client letter is a very good third-party independent evidence to prove your case. So that's one way. And another way, what we do is sometimes we ask for the project documentation. So when you give the project documentation and you say, this is such a complex project, it has relevance to the US as a country because they're solving some problem for a company, and this is indirectly going to impact the entire country as a whole because everybody, the skills they're bringing onto the table, they're solving some business problem, and that is it's a chain reaction. It is indirectly going to impact the country. So we show that nexus, show the project documentation, show the problem, the technical problem they're trying to solve for a company, and show why it is such a complex problem. And anytime you show complexity, you show speciality, you are showing a lot of proof. So these are all the common ways of going back and proving to USCIS that, hey, this case is indeed a specialized occupation.
All right, and maybe if you could just, since we're talking about it, if you could also provide some guidance, on the type and quality of evidence that should be included in a response, to a specialty occupation RFE.
Yeah. So we always typically say, always go back whenever you get an RFE for specialty occupation. There are four important ways of proving a specialty occupation. The good thing is, and these are four prongs, and I'll not go into it, it'll take too much time. But The good thing is USCIS tells us that you can use any prong to prove your job is specialized. And what that means is people have a choice. That being said, we normally advise people to, out of the four requirements, show as many as possible. So, and we start off with the first prong, which is show that the position is complex. Prove, show your project description, explain your project description, your detailed job description. Show the position is complex. That itself is enough to prove. But we go ahead. Detailed job descriptions, use expert opinions, use the client letters if client is willing to give you some documents, use some third-party affidavits, maybe somebody from the industry, put those affidavits,
Mhm.
and together, like put as many documents as possible, give it back to USCIS. And the thing is, you're just trying to convince the officer that yes, this is a specialized occupation, and it is not a simple job. The officers, on the other hand, they are trying to do they're trying to do their job. All they want to do is ensure that only people who provide specialized services are given an approval. So the minute you convince the officer that you are doing something complex, something specialized, not everybody can do it. You can't just train somebody and just get this work done. If you're able to get that message over to the officer, always the officer will approve such a case for specialty occupation.
Absolutely. And I can see, a lot of folks out there have a lot to ask. And thank you so much. And, all this information from our attorney and these experts, they are, at your own risk, take them, and they are not direct advisors. So let's move on to this question from Albert Wilson. He says, why is there an increase in RFEs? F1 visa students completing 1 year of OPT face rigorous RFEs about their work. Can the issue be addressed if companies consult but don't respond?
Um, so this is what we're seeing, like in on the H-1B side, and also the STEM OPT RFEs and the OPT RFEs. What we're seeing is, in terms of the H-1Bs, it is not the RFEs that have increased. We are seeing a lot more questions on somebody maintaining a valid student status. So whether when somebody applies for their initial OPT, or they're applying for their STEM OPT extension, or they're trying to apply for change of status filings, we are seeing a lot of RFEs that talk about their student status. And I think the reason for that is, I think there is a general feeling that people might be violating their student status, because we are hearing and also seeing more and more cases of people, students, who are not doing what they're supposed to do, which is they're supposed to be near the school, not work an off-campus job, but attend classes regularly and pass the classes. And I think USCIS is seeing more and more complaints about people doing third-party jobs, like going out of the campus, doing off-campus jobs. This is not allowed. One cannot do an off-campus job without proper authorization. But apparently, USCIS has been hearing more and more cases of people not staying within the campus, or close to the campus, staying very, very far away from the campus, and they're worried. So what we are seeing is, we are seeing a lot of RFEs, and this is a very new trend. And these are the kind of questions we are seeing in these RFEs. Show us your bank statements. Show us your residential address. How far are you living from the school? And they're asking for a whole bunch of questions around that. And I've seen cases where you submit the documents, they look at your bank statements, and they say, we have seen you sell a lot of money to somebody. We're regularly seeing you get money, and then you're selling money to somebody. So we're seeing questions around their bank statements, around their residential history, and so on. So I think the reason for that is, unfortunately, I think not everybody, most of the people are typically people who follow the rules. But I think there are some students who do off-campus jobs, who do, or during OPT, people are supposed to maintain employment. And then we are seeing some unscrupulous employers who act like they're paying salary to OPT employees, and then they ask the OPT employees to give the money back to them from a back door. This is highly illegal. It's a criminal act. But I think some people are doing it. Very few, very small percentage of people. But what that means is, when USCIS knows about these things, they have a job. They are required to do their job, which is to scrutinize every application. Which is why I think there is an increase in RFEs pertaining to F1 students status. They feel that people are misusing their student status to either do an off-campus job, or get on CPT and start employment from day one, or uh, act like they're working on STEM OPT, act like they're getting paid, but they're not really getting paid because they have all these transactions that show they're getting paid and then they are transferring money out. So I think there is an increase in students who have been doing this, unfortunately. Uh, and I think, especially, I think nowadays because of COVID, there are a lot of things that are happening remotely. So people are able to like stay away from their campus, probably still attend classes. And I think USCIS, they just want to make sure there is no fraud. They want to make sure the programs, the F1 program is progressing properly. And this is probably why I think there is an increase in RFEs regarding OPT status, STEM OPT status, and so on.
Right. So you can't fool anyone. I think I would just say that and stick to being true and avoid fraud or avoid trying to lie and achieving something which is, I mean, doing it the right way is what matters. So I'll just say you stick to it and that'll be best. And
Absolutely. And USCIS,
yes,
again, at some point they will catch it. And when they catch it, they're going to have a permanent bar, which is even more important that people get educated with the law. And I think programs like our show today, it kind of helps put that word outside that people have to be very cautious. They can't get away with it long term. And because I see issues when the issue happens, and I feel so bad. I've had cases where people got deported at the airport because they saw it in their cell phones that somebody was working on an off-campus job, and they found it. They saw cases where on the phone they found that the employer was asking them to pay the money back. These unscrupulous employers. So at some point of time, there is a chance that USCIS will find out, and when that happens, their entire career in US is destroyed. So I think people definitely have to be educated, try to work with the law, always follow the regulations.
absolutely. Do your research properly, stick to the rules, and play safe, I would just say. I have another question from the audience, and this one is from Sadiq. He's asking H-1B Dropbox in Chennai on February 1st, mistakenly listed Google HQ instead of Durham, NC for work, and submitted DS 160. Can I submit another? Can't link to appointment. If you could just give us some advice.
Yeah, typically once the DS-160 is submitted, they more than likely will not be able to make changes to it. And again, if it's an interview, normally what we tell is when you go to the interview, just upfront tell the officer about the changes. But I think that in this case, I think it's a Dropbox appointment. So what I would do is at least reach out to the support line. There is an email for the support when they go into the portal. At least reach out to the support line and just let them know that they want these corrections to be made, and reach out to the consulate.
Absolutely, absolutely. And attorney, I have a lot of questions, and this topic is really vast and deep, and we cannot miss out any important thing because everything is important in this. So I think we will definitely continue more on this topic in the upcoming episode because I have a lot more questions. You already know about it, Chand, and even the audience actually, they are very interested. And this one is from Jim Abril, if I'm pronouncing it right. He's asking, he or he's asking, I just received a letter for RFE related to my fiance's I-129F application this week. I am preparing my response now. However, I've already been waiting for 13 months. How much estimated time does the RFE delay our visa approval?
Sure. So I think the main important thing is once people get an RFE, typically they have 87 days to respond, approximately about 3 months. So in this case, what the applicant has to do is respond to the RFE immediately. And what we are seeing is for these kind of cases, once you respond to the RFE, you're probably going to see a response back in 1 to 2 months. So my guess is the time it takes you to respond to the RFE, so whether it's 1 or 2 months, plus another 1 or 2 months for the officer to review the case and approve the case. So my guess is anywhere between 2 to 4 months is probably the delay you're going to see on the USCIS side. So this is only step one. Once this part is over, since you said it is an I-129F for your fiance, they also have another process at the consulate. So my guess is at least 2 to 4 months, I think, is probably the delay because of this RFE. And that's another reason why we always say sometimes you have to be very, very diligent at the time of initial filing itself, because sometimes if your documentation is not clear, it is not concise, sometimes you run the risk of getting an RFE and delaying your entire processing. But the good news is, at least in 3 to 4 months, at least your fiance will have a solution. Um, and again, this for people who don't know what I-129F is, it is not the H-1B. It's a fiance visa, so it's a family-based visa that I think the poster is asking about.
Right, right. And Jim Abril, I hope that you have it. There's a follow-up question. He's actually watching us right now. So he's asking, I've been overseas with my fiance for the past 6 months, so I can easily provide whatever evidence they could possibly ask for.
Sure, sure. Because most of the time, these RFEs, they ask about the legitimacy of the relationship. They want to really make sure somebody is a fiance. How did they meet? And
Right.
they're not really wanting to get married for the sake of green card. And I think, as Jim has pointed out, he has been living overseas with the fiance for the last 6 months. That itself is great proof that they really want to like get married and live together. So for their visa, I mean, I think from evidentiary perspective, the case will not be too difficult. It's unfortunately just the delay. That visa is pretty slow, so it's just their timeline. But I think approval, I don't think they will have an approval problem.
All right. Patience is virtue, Jim. You've already waited a lot, and I think your time is coming. So let's hope for the best. And let's take up this one from Pradeep. And he's asking, I came to know that for each passport, only one registration will be considered during the lottery process. So we can do multiple registrations, but for the lottery, it will be considered as one, right?
So when you say we can do multiple registrations, the beneficiary, the employee cannot do any registration. The company that made the offer, they are the ones that will register. And again, one thing very important is, if you get multiple offers from independent companies, they are okay to go ahead. Just make sure the companies are not colluding and they're not trying to register because they're trying to collude and file it in the lottery. That being said, there is no additional advantage. There is no additional chance of somebody getting picked up in the lottery because two independent companies are filing. But say you have two genuine bona fide offers, say one from Microsoft, one for Apple, and you're not able to decide right now if you want to go stick with Microsoft or stick with Apple. But you know that the companies are independent, the companies are not colluding. The rule is, yes, you can have both the companies file on your behalf, and tomorrow, because you get selected through your passport. So if your passport is selected, Microsoft will get notified, Google will get notified that their registration got selected. So tomorrow, Microsoft can file for you, Google can file for you, and that is completely legitimate. So, so when you say multiple registrations, if both the companies are independent, they have a genuine job, those two companies can go ahead, or three companies can go ahead and file the registration. It is not going to give you any additional benefit in terms of your probability in getting selected in the lottery. But because if you're not really sure who you want to select right now, then again, it's probably okay because the companies are independent and they're doing it independently. And your chances are not really high, but what you're doing is you're delaying your acceptance with one company for some time down the line.
Okay. And thank you so much, Jim, for your questions and also Pradeep. And, Chand, I think we are already an hour into the show, so I'm sure I don't have a chance to hold you much longer. But if I may ask, how long can you stick with us so that we can take up a few more
Sure, sure, yeah.
questions maybe before we
Sure,
leave?
sure, yeah. We can take some questions.
Okay, okay. So let's take this one from Helen Fernandez. And this one is, what is the average number of months to get LC approval these days, especially EB3 unskilled?
Sure. So for the folks that are, here who are more aware of H-1B, so LC is labor certification. That is like the first step in the green card process. And it's also commonly called as the PERM application. So the PERM, labor, these all refer to the same thing. And I think the poster is basically saying like, what is the average number of months for the approval? Answer is, unfortunately, a very long time, and that long time is almost 12 minimum to 14 months. So 12 to 14 months is what we are seeing. And in my career, I started my legal career in 2011, so it's almost close to 12, 13 years. I've never seen a perm labor application take more than a year, almost 14 months. This is the longest I've seen. Things are unfortunately extremely slow with labor filings, the green card labor filings. Uh, and there is a reason for it. They changed the process last year. After a very long time, they changed the way they do their labor certifications. And extremely bad. 12 to 14 months is what somebody can expect for their perm labor to be certified. And what this means is for a lot of those folks that are on H-1B, you only have 6 years. After 6 years, you cannot be on H-1B unless your employer starts your labor certification process, which is this LC. So people who are on H-1B, you should be aware that the labor certification is extremely slow. And what that means is you should talk to your employers about starting the green card process as soon as possible. If not, the labor certification is taking extremely long time. And tomorrow, if your 6 years on H-1B is up, you'll be in trouble. Okay. So labor certification is extremely slow right now. I just hope that the process will get a little bit faster in the next couple of months. But reality is, I don't think anything will change in the next 6 months.
Okay, but let's not, let our spirits die. Let's keep the hopes up and let's hope for the best. Yeah. And another question before we go, I think let's take this one from MK on YouTube. And the employer name printed on my H-1B stamp is wrong. And I didn't notice at the time. The name is entirely different, not a typo. Is there a way to get it fixed from the USA?
Sure. So I'm assuming that the approval copy was correct and the receipt number on the visa is correct. It's probably just the name on the stamp. And if the employee is already in US, this is what he can do. Because he's already in US, the first thing one should do is download your I-94. Make sure your I-94 is accurate. If your I-94 is accurate, the I-94 will not have your employer name, but it will have your expiration date. So at least if your I-94 is valid with your name and the valid end date, you are good as long as you're in the country, because the visa is only for coming into the country. Once you are into the country, it is the I-94 that governs your status. If your I-94 is valid, you're good to stay in the country. You cannot really change the visa stamp in the country, but next time you are going out of the country, let the consulate know and get it fixed. You can't unfortunately get the visa stamp fixed in US. You have to go back to the consulate. But if you're already in US, don't worry. Just look at your I-94. Make sure your I-94 is accurate. But next time you step out of the country, reach out to the consulate and let them know, and then they'll let you know, and you should be able to fix it.
All right. And I have another question. This one is on LinkedIn from John Paul. And this one is okay, one question, please. So, okay, please post your question, John, if you have any. We will take that up for you. And anyway, if you have a lot more questions, you can directly contact Attorney Chan Parvataneni. And also me, you can call me up or message me on the number 408-335-6444. And as for Attorney Chan, okay, so John is watching. Thank you, John. You have your question here. For Canadian, I am in USA as TN. I think he's still typing. Let's just hang on. But definitely, I mean, okay, he's asking, can I file H-1B in Canada?
Sure. So TN is a great visa that a lot of Canadians use, and you can use it for specialized jobs. It's used by Canadians and Mexicans, Mexican nationals. And so TN has some restrictions, and that restriction is when somebody wants to get the green card filings done. So TN has certain restrictions because TN, the intent of the visa is a little different. So normally, what we suggest if somebody's on TN is try to get onto H-1B if your long-term goal is to immigrate to US and get the green card filings done. So definitely, if somebody's on TN, if your long-term goal is to get a green card in US, definitely explore the H-1B option and ask your employer to file the H-1B if your goal is to get a green card down the line. If your goal is to just work as a temporary non-immigrant worker, I would think TN is a little bit more flexible, more powerful. So TN is good enough. But the times that I normally suggest TN folks to move over to H-1B is when they have long term, they want green cards to be filed. And from that perspective, H-1B is a lot more flexible visa. So definitely it can be done. And we have these cases every year. People on TN wanting to move over to H-1B.
All right, all right. John, I hope you've got your doubts cleared. And if you have anything else, please just post them and we are here. And, we took up questions from Jim earlier. He says thank you. So thank you also, Jim, for putting that up. And we have more clarity on that also. This one is from Sagarika on YouTube. Can you travel outside the US when your H-1B transfer RFE is in progress?
Yeah, definitely. You can transfer if it's a H-1B transfer, H-1B to H-1B transfer. You can definitely go out of the country. The only time you cannot go out of the country is typically when your H-1B is filed as a change of status. So if somebody is trying to convert from F1 to H1 or from H4 to H1, you have a change of status uh, filing done along with your H1. You should not travel. But if it is just H1B to H1B, you're allowed to travel. Just make sure that you check with your attorney so they can talk about the timing when you need to come back, wait for the approval, and so on. But you're good to travel. Let the company answer the RFE, get an approval, and then you can come back. So traveling is not going to invalidate your the transfer petition.
All right. So, Sagarika, you can travel. And also, John Paul says thank you. And thank you to you too, John Paul. And thank you so much, Attorney Chand, today, for taking time out of your busy schedule and answering these questions and staying with us for this show, which was definitely very enlightening under this very important topic.
Yeah, thank you so much, Nipasa. And we'll meet again and then we'll continue more discussion on the H1B because it's the H1B season. Registration starts March 6th, and a lot of folks, I think, in spite of so many layoffs, what I'm seeing is IT industry is still strong. A lot of people, a lot of our clients are already in the process of hiring, and we're already getting data for our filings next month. So the market is still pretty strong. There is still a lot of shortage of very talented, specialized IT employees. So I think all of us, as we get ready for the new H-1B cap season that's about to start in a month, it'll be interesting to see how the U.S. economy plays out and how the IT market in U.S. Plays out. But definitely, there's a lot of shortage still in U.S.
For sure, for sure. And we have so many questions. I myself have so many questions. I can only imagine all the people out there who are going through this process, how much more they want to contact you, maybe. And really, so since we were talking about talking more, and I think I will just say, all you folks out there, thank you for tuning in today. We are going to catch up next Thursday, the same time again at 2 p.m. EST, and we are going to catch up more on this topic. And thank you for the information, also, Attorney Chan, for the March info, so that people can be on their toes. Go get it done, I would say. And all the very best. And of course, stay tuned. Because we keep exploring the nuances of H-1B visa applications, and of course, you can always gain invaluable advice from our expert guests, and today being Attorney Chand himself. And remember, if you have any questions, just keep them dropping. And after this live show, we are going to publish this, and maybe you can go through this whole show we had. And if you have more doubts, also keep commenting. And we are Immigration and Jobs Talk Show on YouTube. That's our handle. Don't forget to hit the subscribe button as well and stay with us. And you can also contact me at nipa@highrightypeople.com. Mail me, even if you want the attorney's contact details, I could share them with you. So just I'm just a call away or a message away. Just write to me or call me on the number 408-335-6444. And definitely don't forget to visit our website, www.highrightypeople.com. Thank you so much, Tony Chan. Once again, I am looking
Thank you.
forward for our next session already. So here's wishing you a very great day ahead.
Thank you very much. Thanks, everybody.
Thank you. Thank you, all you folks also. Thank you for joining in. I'll see you. Stay tuned to Immigration and Jobs Talk Show. It's Nipasa Pradhan saying bye for now.